So, topic again for discussion here is going to be after the sale. I get calls. We've had a few rainstorms recently, and I always get the call from agents, experienced and newer. Buyers moved into the house 2 weeks ago. First rainstorm happened, and there's water in the basement. What kind of recourse do we have against the seller?
Right.
And I always say, look, if it's on the disclosure statement, not much because you had an opportunity to inspect it, or you should have. But sometimes it's not disclosed, and then it becomes what we call that he said, she said. No, I've never had water in the basement. Now all of a sudden these environmental conditions are just perfect to get 2 inches of water in the basement where maybe there wasn't before. I always tell our agents, look, if you go to ABC Waterproofing and they say, yeah, we were out there 2 weeks ago and gave them a quote for $7,000 of water remediation, now you got a smoking gun in your hand you can take to an attorney and go, look, I want some recourse on this.
True.
And is it as simple as that, or how do we disprove anything on a seller's disclosure statement if we don't have that smoking gun?
Right. I would say a couple of things regarding that. If you get that call a couple weeks after, the first thing I would do is try to carefully document. Can I come out and look at it? Go out and take pictures. You'll be surprised how many times they pulled out the old shrubs around the house and put in new shrubs and changed the grading. And so it's nothing to do with a pre-existing condition in the home. It's actually something that the buyer perhaps has done to the home. Second thing is, take careful time, place, date notes so that we can determine. I recently had a case up in Traverse City with Judge Power, and he said, this is the 5th 100-year storm I've had in the last year. They have standards for what are significant storms, but there are, was it an abnormal, environmental condition that occurred that, might explain it. We haven't had a storm like that. And, the one I had up in the Torch Lake area, they had 12 inches of rain, I think it was, in 24 hours. Well, there hasn't been a 12-inch recordation since they've been recording in 18 whatever it is at the Traverse City Weather Station. They haven't ever had over 8 inches of rain, and this was a 12-inch rain in this localized place.
Right.
It wasn't 12 inches at the Traverse City Weather Station. So I think documentation is the first thing you can do to help yourself and to limit exposure there, because we understand or can rule out a number of things that otherwise could be iffy what happened there, that could fall back on us, so to speak, or on our client.
Well, and we always tell our agents too, look, the purchase agreement is between the buyer and the seller. It's not our job necessarily after the sale to perform legal services for them.
Absolutely
we
not.
can be the conduit of the information to the other agent to say, hey, look, we have an issue. Here's what we know, and here's what their plan is right now. Right. And a lot of times that's just go seek advice from an attorney and see what recourse you do have.
Right. And one of the things I think it's important for the agent, though, is that almost always we're joined in, because they'll say there was some statement made or something.
Right.
I mentioned to you there was a recent case decided August 18th by the Court of Appeals, and I don't know what the date is today, August 31, so 2 weeks ago. So now we've dated this conversation. But
we've got precedents, too.
So. Yeah. And I don't even remember the name of the case, but it was a boundary dispute, basically, over 14 feet on a property. And one of the things, there were really 3 points in that case. We talked about one of them. We didn't talk about the second one, which is really, they said that it's an as-is sale, and the integration clause actually means something. So that when you say, I'm not relying upon any other statement or thing that's said, they said that means that. And so that's a good reaffirmation of that point. So at closing, we always get a document to sign that says, it's in the buy-sell, of course, that we're not relying on anything prior to this unless we've stated what it is. But you do the same thing at closing. If you're on the buyer's side and you're relying upon statements that have been made to you by anybody, the seller's agent, which would essentially theoretically be on behalf of the seller, or whatever, you need to document those in that document before you sign it. So if they've told you, yes, you can rent this condo, okay, you should say, I'm relying upon the representation of the seller's agent on behalf of seller, okay, that this condo can be rented. So when you realize, a day or two later that when you flip to, 3 pages later and it says you have to live there a year before you can rent it, well, in that situation, you would then you're relying upon that representation of the seller's agent that you can do that. So it's important on the buyer's side, if you're representing buyers, that you get that documented. If you're on the seller side, the good news is that if they haven't documented it, then they can't really rely on it very strongly, unless it rises to the level of being fraud to induce them to get into the contract, which is a tough standard to hit. So,
Right.
So anyway,
Very tough to prove in court. So on the seller side, we would give the advice, look, disclose, disclose, disclose. Whatever you know should be said in writing via the disclosure statement or supplemental documentation
Right.
if necessary.
or an addendum if it comes out during the course of negotiations, perhaps.
Because we've seen a lot of buyers waive inspections to be competitive, but it does not absolve the seller from their legal responsibility to disclose defects in the property.
Correct.
Secondly, on the buyer's side, they are signing a document at closing stating that they had an opportunity to inspect or waived it, and that they're buying it as is, and that does relieve the seller from a lot of obligation beyond the sale if they didn't know something.
Right. You missed a digit there. You had a fourth thing you had to go
Did
to.
I?
What was the fourth
Okay.
point?
Yeah, I don't know. I didn't write it on my hand today, so.
So anyway, yeah, I would agree with you that, exposure after the sale, one of the best ways to limit that is to have been careful and diligent on the front end.
Yep.
And you could take the position that if I'm accurate in my disclosure statement, it may diminish the value of the property. Well, I'd rather diminish the value of the property on behalf of myself and my seller, quite honestly, than oversell it and simply be stuck in a lawsuit, for the next 3 years afterwards, because you won't win. Even if you win, you will lose cost-wise on that. So I think accurate, fair disclosures are something that we should strive for in real estate transactions. The second point of the case, I guess, that we talked about that was just decided here on August 18th by the Court of Appeals in Michigan was there was an out of the blue statement by a neighbor that your garage is on my property, but there was no context to it, and the people didn't back it up with any statements, documentations, a survey, or anything else, and so they simply put unknown in that case, and they said, well, it wasn't known, and therefore the buyer was on notice. So if you're buyer's side and there's an unknown, this Court of Appeals case says that you're now on notice that you have to figure out what unknown means on your own and figure out whether there's really an issue. In that case, they're saying the buyer should have taken it upon themselves either to have insisted on a survey from seller or to have themselves gotten a survey so they could resolve the issue. So I would not encourage people to put unknown typically as the, unless, we see it, for example, do you own oil and gas rights? I have no idea.
We don't know
unknown,
that. Yeah.
right? But if I actually know there's an issue, and I would say in that case, if I had represented the seller, I probably would have said, you should have said a neighbor came over and said this, but I'm not aware that it's legitimate. I think that would have been a better disclosure and would have covered them even better than what occurred in this case, because they did wind up in a lawsuit, even though the seller won it in that case. As the defendant, I think that if they'd have had something even clearer in that disclosure, they'd have just been out of it from the get-go, because they'd said, hey, we told you about it.
Yeah.
So while they won in the end, did they win if they had to deal with a lawyer? Because we're not pleasant people to work. Well, I don't mean that really, but
Some of my favorite people are
yeah,
attorneys.
exactly. As long as you're fishing, right?
Yeah. So, two things on that. One is marking no on a disclosure statement also indicates that you have specific knowledge that there is no.
Nothing.
And so my experience in court, the one time I've been to court for my own, well, it wasn't my transaction, but I represented the buyer. The buyer took the seller to small claims court for removal of a buried oil tank. And it came down to the magistrate, not the judge, saying, look, seller, you marked no. Now you're saying you didn't know that there was an oil tank back there. You said you have specific knowledge that there wasn't one, so they ruled in favor of the buyer. And so marking no versus unknown can lead, you better know that the answer is no before you mark no also. So.
I think that's fair, although in the case that you cite, my argument would be that I had absolutely no knowledge, and I've looked around the property and there's no markers, there's no indication, there's no standing pipe, so I think I could safely, and there's no history of the property that would suggest there ever should have been one, so I put no, and it turns out there is one, because it's what's in my head, it's my knowledge that I'm putting down. So, it gets into a fine line what you do there, because if you go through and put unknown on everything, I'm not buying your property when you put unknown through the thing. So, you get to some fine slices there in terms of how you should come out on that. But no does indicate if I noticed that standing pipe, but I put no anyway. Well, that's a different kind of thing.
And that was the
So-
case. We bought the property in January when there was snow this deep. Snow melts. Small town. Buyer calls the seller, says, "Hey, what's this pipe sticking up?" "Oh, that's an old oil tank."
Right.
So didn't record the phone conversation, but
Right.
that would have been better if we had. But
Which
wasn't.
is our next
wasn't the
topic.
case.
You
Yeah.
actually can record a phone conversation between two people without notice to the second person. In Michigan, there's a recent case that affirms that. But you have to be very careful. If your buyer and seller are having a conversation and you're listening in and you're recording it, you're now eavesdropping and you're breaking the law. Only a participant in the conversation can record it. So, but yeah, he said, she said, of course, is the bane of these types of things. And when you throw a few dollars on the table and have to fight about them, it's amazing how people will say things that they might not have otherwise said. But yeah, I agree with you that that when you say, unknown, you should say that if you truly have no idea on something, like oil and gas rights is the one that comes to mind. But
Right.
you notice on the form, it's not yes, no, or unknown. Those aren't check boxes on there. You get to fill something
Some
in.
explanation along with
So,
it.
as opposed to no in that case, you could say unknown to me,
Right.
or I have no knowledge that one exists, or what you could decide to be a little more creative if you think there's one that needs a little more creativity.
So now in a shifting market, we're seeing more and more people actually getting inspections done, which is good.
Right. And by shifting, we mean that the market was, I'm not a realtor like you, but 6 months ago it was so hot that if you didn't bring a cash offer, no contingency, no inspections, you weren't going to get the property.
Right.
Somebody else was, right? And now we're seeing it shift where it's a little more discerning and you can actually put a contingency in of some sort and you might still get the property.
Right.
Is that what we're talking about?
That's exactly what we're talking about. So now buyer has the opportunity to do inspections. Attic is full of mold. And we've had this instance where the seller says, "Okay, here's your mutual release, go away, but don't send me the copy of the inspection report as
Right.
proof." At that point, listing agent now knows about a material defect. Seller should know about a material defect as to why the deal fell apart. And both agent and seller have an opportunity and an obligation to amend the seller's disclosure statement and disclose to all known buyers. The question I have is, what's the buyer's agent responsibility if that doesn't happen? So now you have a buyer's agent out there whose buyer's moved on to another property, and maybe it's somebody in my office and I'm writing an offer, water cooler talk, 1234 Main Street, my buyer loves it, it's going to go write an offer this afternoon on it. And Dave Smith raises his hand and goes, "Oh, wait a minute. Does he have an obligation to tell me that there's mold in that attic, or is that confidential information between he and his buyer?"
Well, that's really interesting because you're
Kind of a curveball I threw at you.
It is.
So-
Thanks. Yeah. So
Wheels start turning while we're sitting here.
Well,
so.
your ethics rules that you all follow from the national, right?
Yeah.
Which of course are embodied or adopted by your local.
It is that
real
year.
estate
Take your
board.
code of ethics training soon, too, before the end of the year,
Yeah.
please. So,
So if you read, and I won't get the paragraph right without looking at the last letter I wrote last week, but I think it's down around maybe Article 15. You actually do have a confidentiality obligation to your client in a transaction. So there are certain things that you can't say.
right.
So let's break it down a little bit. If you look at it, I believe that both the seller and the seller's agent have an obligation before they move forward to do two things. First is determine whether it's really mold or not, is step one. And then fork A under step one is remediate, fix.
Okay.
Or B is we're going to leave it as is.
I'm going to need a lot more fingers and hands here on this
Yeah,
one.
there
I
you
think,
go.
so.
But what occurs though, and I've had two of these in the last probably year or 16 months, 18 months, is we get someone, for example, the fee appraiser goes in to determine value of the property for the lender, and they say, "Oh, we see some discoloration. One was in the rafters or the trussing, and one was actually the decking boards. I see discoloration. It's a, quote, mold-like appearance."
Yep.
Okay. Is it even mold? Okay. Is it even a hazardous issue? So before you jump to the conclusion that there's mold, it's probably a good idea to determine actually is there an issue.
Get it tested.
And
Yeah.
if there's not an issue, then I don't know that you have an obligation necessarily to disclose that there was mold or what the issue is. So there's an interim there, okay? If it turns out that it is mold or likely mold or something, is it hazardous mold? Is it one that you have to treat or remediate? There are some molds that actually aren't harmful to people, and that if you sufficiently dry them out, they'll go away or whatever. I'm not a mold expert, of course, so point being, I think that if you are aware that there actually is an issue, you need to decide on fork A, remediate, or fork B, sell it. But in either case, I think then you have to disclose that existed if you're going to be straight in your transactions. And if you want to be in the business for a period of time, you're going to find that it's always better to be straight, and you need to encourage your sellers to be straight. If your seller's unwilling to disclose it, then I think you have to determine whether or not you can even go forward with the relationship at that point in time, because selling one property should never be so important to you that you want to do something wrong. I have an old friend who tells me there are two things in life, right and wrong, and there's really nothing in between. And I think that's sort of the situation here, is that if you're aware that the issue's there, you absolutely must disclose it. So back to your question, is that in this case, I now have a subsequent buyer, and they have not amended. We're not the agent for the seller. I think that they have a right to speak up within the organization and disclose that. I don't think that causes them any problem. And I suppose you could say that you've intentionally interfered with a potential contractual relationship or expectancy between the seller and this buyer, but you've protected your buyer, who is the Keller Williams client. And I think that's your job, and I think you'd be okay doing that.
Okay, good to know. Additionally, coming out of a shifting market is negotiation through inspections and writing addendums. Probably topic 3 for today, maybe if we're up to 4, I don't know. Maybe
Coming up in our next episode, how to
subtopic,
write an addendum.